because I'm delighted to be joined now by Edward Henry, QC, a regulation and criminal law specialist at Mountford Chambers. He and I have also been having exchanges on social media. Now, that's him there, not standing very, very still. It's because we couldn't get the television link up to him, and so we've now got him on the telephone, I hope. Edward, are you hearing me loud and clear? Edward, are you there?
Alastair, thank you so much. I've got a perfect face for radio. So I think it's better for everybody that I'm appearing or not appearing. But could I just pick up on the Don from Oriel College, Oxford? She talked about if I pulled down a statue of Chairman Mao in China. If she pulled down a statue of Chairman Mao in China, she would end up in a penal colony, or she would have a bullet in the back of her skull. We live in a democracy, and much, much bigger than this Colston statue is the fact that we accept the verdict of a jury.
Yeah.
The verdict of a jury is a fundamental part of our democracy, because otherwise anybody going before a court would literally be squeezed between a professional judge appointed by the state and a prosecutor appointed by the state. It's the jury for serious offences, which is a magnificent bulwark against oppression and also against injustice.
Sure.
So if I could just begin...
No, I'm glad. I take your point completely, and it is a useful and sensible piece of clarity. I tell you where I've got the problem. Not a conversation between an interested journalist and an eminent QC. What an awful lot of folk, and you may have heard it when I read out the emails, and we did some earlier on, the public at large don't get that. They are convinced in their own minds that this will set a precedent, and even if it's not a precedent in law, it will give the green light to people to go out and tear down statues they don't like, whether it's a slave trader or Karl Marx in Highgate Cemetery.
Well, I understand entirely the public's outrage, because, you know, there will be some people who will applaud it, and there will be some people who will profoundly disagree with it. But the reason, I think, is that we've just got to get back to fundamentals. The best justice is local justice. And this case was tried in Bristol with a senior resident judge in Bristol, His Honour Judge Blair, Queen's Counsel, and it was a jury of people from Bristol. And I think, therefore, that if you are miles away from Bristol, you may not necessarily appreciate the nuances and the very, very, the fervid atmosphere that has existed in Bristol since the 1990s over the statue of Edward Colston.
Absolutely.
And so local justice is the best justice.
And that's a crucial nuance, because people are pointing out that the defence barrister said, your judgment will be echoing around the world. It's that important. Don't be on the wrong side of history. And the judge said, no. But that was very strongly the feeling there in the court. Let me ask you one final thing, Edward, if I may. Again, on my correspondence, and it's only social media, but it's emails as well. What folk can't get their heads around is that a chunk of bronze representing a slave trader infringes the human rights of these four people not to be forced to see it. Does that add up in law?
Well, it does, because, you see, this was not a perverse verdict where they had absolutely no defence, but they were simply running a political defence, because then they wouldn't be allowed to have barristers, because no barrister can represent somebody who has absolutely no defence. The defence has been withdrawn by a judge. And we see that time and time again. For example, Randall and Pottle, who sprung George Blake from Wormwood Scrubs in '66, their barristers had to withdraw when the abuse of process argument failed, and they defended themselves. So these defendants had excellent counsel. The prosecution was represented by superb counsel. So there's no inequality of arms. They had three defences. They had the defence of lawful excuse, because they were concerned that his continued presence on that plinth was going to cause alarm and distress to people who were the descendants of slaves, that it was an indecent display under the Indecent Display Control Act.
Sure.
And also, then this did pertain to them. It was the fact that it would have had a disproportionate infringement upon their human rights.
Edward, I'm going to book you to come back and have a longer conversation when we finally know Suella Braverman's decision. But for the time being, thanks for getting through the technology and appearing there by telephone rather than by TV. That's Edward Henry QC, specialist at Mountford Chambers.